Good afternoon. I hope you all had a nice lunch. We'll begin the last panel of the colloquium, which will be followed by the high-level roundtable. So, distinguished representatives, guests, ladies and gentlemen, having gone through a number of legal, international trade law-related issues that could arise with regard to climate change, I'm happy to welcome all of you to this panel, which deals with climate change dispute resolution. As you know, UNCITRAL is a well-known name in the field of dispute resolutions, having created and functioning as the guardian of the international legal frameworks for arbitration and, more recently, for mediation. With works currently being carried out by Working Group 3 and ISDS reform, which I perform as the Secretary, to reform ISDS, the current system, and by Working Group 2 to create additional means to resolve disputes in a more efficient manner, having concluded its work on expedited arbitration rules. Supporting the legislative work of different working groups, I've come to realize that the definitions in the legal text may be quite determinative in framing the scope of the legislative work, and the first questions that the audience may have is, what is the meaning of a climate change dispute or climate change dispute resolutions? Now, having spoken with the distinguished speakers that we have on the panel, I can be quite sure that every one of you might have a different idea of what a climate change dispute is and the means to resolve such disputes. The only clear answer that I have is that climate change itself is not disputed. We're not disputing whether there is climate change and what the cause of it is. But today's panel will illustrate to you the wide spectrum of disputes as we explore the current trends in climate change disputes and their legal implications. For those of you who might be interested, ICC had issued a report in 2019 titled Resolving Climate Change-Related Disputes Through Arbitration and ADR, which outlines some of the issues that the panel will be discussing. What are such disputes, the use of ADR and the benefits thereof, and the report identified specific procedural elements which related to the use of experts, the need to ensure urgent and early resolution, applicable laws, transparency, third-party participation, and costs, among others. So at this juncture, I'm very pleased to have 4 wonderful speakers on this panel, all very knowledgeable and very qualified, who can dig a little bit deeper into these issues. And as had been for the last 2 days for myself, I'm here very excited to learn more from them. So I'm switching into a student mode to ask more questions and actually to get some answers from the speakers. 2 of the speakers that are speaking, Ms. Aisha Abdallah and Ms. Tomoko Ishikawa, who you see on the screen, are joining us remotely. Ms. Abdallah is a partner in Anjawala and Kana, based in Nairobi, and Professor Ishikawa is the Vice Dean at the Graduate School of International Development at Nagoya University. And as you see, 2 of the speakers are here with us today. Ms. Miles moderated session 3, and she's a barrister at the 20 Essex and is a representative of the Net Zero Lawyer Alliance. Ms. Magnuson, on my left, is the co-founder of Climate Change Council, based in Stockholm. The detailed CVs and the impressive careers that they have can be found on the Colloquium webpage. Now, due to the limited time available for us to engage in live discussions, we have asked the 2 remote speakers to send pre-recorded videos, but they are with us today and will be participating live in the Q&A discussions. So without further ado, let me pass the floor to Wendy to kickstart the discussions and provide an overview of the relationship between the legal frameworks of international arbitration and climate change. Wendy, you have the floor.
Thank you so much, Jay, and thank you so much, UNCITRAL, for putting this on the agenda for this meeting. I've inadvertently renamed the colloquium. Apologies for that, Angelo. So where Ipshita did not want to venture into philosophy and revisiting economics ruling the world, that's exactly where I'm going to go. And I want to talk to you about how the system of international arbitration sits and intersects with the system of international climate change law. And it's a challenge, and the reason I want to confront it is because it is a challenge, which I think this body might be interested in looking at. First of all, if we think about international arbitration, derives from private international law or the conflicts of law ultimately. They're near universal principles and rules, and they're reinforced by what we can describe as a top-down approach, informed by the New York Convention in relation to arbitral awards, the ICSID Convention for investor state awards, but also for judgments as well, the Hague Convention, Rome Convention, and general principles of law, Lis Pendens, res judicata. Those principles, those rules, and those conventions are uniform to a significant extent and top-down. Contrast with that international climate laws. The Paris Agreement is very much a deliberate bottom-up architecture. 197 states design their own nationally determined contributions for what suits within that country for the global goal of reducing greenhouse gas emissions. Differentiated responsibility is a very important principle preserved in there. Single global goal to mitigate, adapt, and build resilience, but how that goal is achieved, 197 different strands of strategy. Both of those systems exist and operate at the confluence of public and private international law. So the backstory to how we get there, to our public and private international, you probably can't read this, but anyone who's spoken to me in the last 6 months would have been recommended this book, so welcome. Globalists, The End of Empire and Birth of Neoliberalism by a Canadian historian, Quinn Slobodian, is an absolutely terrific book, and he says in this quote, if you can't read it, in the course of World War I, the sacred nature of private property across borders was violated. The space of the private capitalist was desecrated. The era after 1918 was marked by an attempt to re-establish what international economic lawyers and economists saw as the correct balance between the public work of government and the private world of property and contract. Concretely, this translated into a series of projects of capitalist internationalization. Investment must be able to cross borders back and forth without fear of obstacles or expropriation. Capital needed to become cosmopolitan again. So there we were in the 1920s, and the place where this conversation was taking place was right here in Vienna. So the economists that you all probably know well from your studies, Hayek, Mises, Schmidt, those gentlemen were working with the International Chamber of Commerce in Vienna and looking at moving from a world of trade governed by imperium, moving into a world of trade and investment governed by dominium, property being the dominant protection. So then we have, from there, the Geneva Protocol, which was the predecessor, the grandmother perhaps, to the New York Convention on the Enforcement of Arbitral Awards, 1923. Not a huge uptake, fairly small number of countries, but that came of this time, of this birth, of an attempt to create a blueprint for how we protect property rights cross-border. New York Convention, 1958. Now, when it was put to ECOSOC in 1952-53, the draft that had been prepared by the International Chamber of Commerce, ECOSOC said, we will not accept your original draft for the enforcement of international arbitral awards because we will not circumvent the law of nations. This ultimately is a regime that must come back to the national courts of states. So it was called, as you all know, the International Convention on the Enforcement of Foreign Arbitral Awards because it's foreign to the enforcing national court. Then the ICSID Convention shortly after in 1966, and then UNCITRAL, the same year as the ICSID Convention, accelerated the implementation of the New York Convention. The UNCITRAL arbitration rules, first rules in 1976, then the model law in 1985. And what's quite interesting is there were only about 60 states that had signed up to the New York Convention prior to the UNCITRAL model law, and now there's 169. So that model law had a deep accelerating effect of the implementation of the framework legislation to get that convention in practice, to get the uniformity across borders. So UNCITRAL, of course, deals with the laws applicable to private parties and international transactions, and this whole body, and we heard a little bit of this from Ipshita in her presentation on the choice of law being a very difficult issue if you're trying to track uniformity through supply chains. Also for dispute resolution, which often is the only and ultimate enforcement place for these commitments, obligations, rights, the choice of forum is critically important. Enforcement of judgments is obviously subject to a separate regime, less universal than the enforcement of arbitral awards, but the laws of international commerce all sit in this body of law that we call international economic law. Obviously, there's much more that fits in that category, but our private international law and the world of UNCITRAL sits within that international economic law. So I want to take that and now put it against the system of climate change law. And so that the provenance of our modern climate change law is the 1992 Rio Declaration and Conventions. And this I find really interesting. The Rio Declaration on Environment and Development, 1992, recognises two things. A lot of things, but two critically important things for our purposes. The right of states under international economic law to exploit their own resources pursuant to their own environmental policies, and the duty of states under international environmental law to ensure activities within their jurisdictional control do not cause damage to the environment of other states. So the two bodies of law need to work together. And if you look at, we'll come to it in a minute, the UN Convention, the UNFCCC came out of Rio 1992, as did two other really important environmental conventions, biological diversity and combating desertification. So just looking at the Paris Agreement for a moment, the UNFCCC and then the Paris Agreement in 2015 both have, while we're talking about the coming together of the worlds of international arbitration and climate change law, they have arbitration provisions. But they're opt-in, Article 24 of the Paris Agreement, Article 14 of the UNFCCC, they're opt-in, and only 3 states have ever opted in, Tuvalu, Solomon Islands, and the Netherlands. The Paris Agreement, some might think, and I think this is what's critically important for our purposes today, Paris Agreement qua investment treaty. If the Paris Agreement is about aligning finance flows, if it's about reaching mitigation goals that require $6 trillion a year of investment, if it's about adaptation that requires even more money in investment, this is private sector investment, if the cover decision extends to non-party stakeholders, is this not sort of an investment treaty? Is not investment in many ways the pathway to building these new systems with lower greenhouse gas emissions? So the Paris Agreement mitigation obligations, obviously, according to the IEA, requires exponential scaling up of investment, not just in energy systems, although that 62% of the problem would be solved by electrification. Also transport systems, energy-efficient infrastructure, and industry. Adaptation and resilience building is another of those investment pathways, if you like, in the Paris Agreement, and ultimately global finance flows to align with the Paris Agreement under Article 21C. So the International Arbitration Framework, it exists to protect and promote cross-border investment, commercial and investor state. It's been unbelievably successful for mobilising and protecting investment, for providing certainty to investors across borders. Given that we are entering, in fact, we're already in probably the biggest new investment, transitional investment phase of modern history, one would certainly look to those frameworks to see if they can be maximised, utilised, and if they're indeed fit for purpose. So that brings me to fit for purpose. What do we want these dispute resolution mechanisms, international arbitration in particular, to achieve? What we want it to achieve is to balance the global carbon budget. And there is only one carbon budget. You know, carbon, like supply chains, like fish, it knows no borders. So carbon, the atmosphere, greenhouse gases, there's just the one budget, net zero once in total. But there's 197 bottom-up country plans in the nationally determined contributions. So it's 197 strategies to get to one goal. And then there's two broad mitigation approaches if we just focus on getting the carbon down: reduction and removals. We've heard a lot about removals the last few days with VCM and Article 6, but reduction is really the main game in town. Removals is what you cannot reduce. And three market mechanism systems for removal. And again, talked about those yesterday, Article 6, the VCMs and the compliance mechanisms, mostly through emissions trading schemes. So this is the bathtub, and hopefully UNCITRAL will share you these slides. The bathtub is attributed to John Lang, who's with Net Zero Tracker, and he designs these wonderful infographics for us. And what that is showing you, and I don't know how, on the right-hand side is the problem we're in, and that black overflow into the bathtub is our excessive greenhouse gas emissions. We need to turn that tap down, and that's our reduction. Reduce the flow of emissions into that bathtub that's desperately about to overflow. That red line, that's the offsetting your excess emissions. But if you look on the left-hand side of the bathtub, that's your natural carbon cycle. So much of the forests and nature-based solutions and blue carbon sinks already exist in the natural carbon system. So we can't count those for our excess. There's a balance. Every time we breathe, we're releasing CO2. There's a balance that we need to keep in the atmosphere before we even move into a trading conversation. So one bathtub, one global budget, all these systems have to sing to it. So what we have right now is an incredibly fragmented approach in national legislation and also in different voluntary initiatives. And it's difficult within the Paris regime to see it any other way because you have 197 different autonomous plans. And in that operating environment, we are seeing, as we've been hearing today, some convergence. We're seeing some real convergence. The public international law is clear. The national-based policies on NDCs, there's some uniformity, not a whole lot yet. National laws to implement those NDCs, we're seeing some commonality. But remember from yesterday that TCF-based rules on disclosure, only 6 states so far of the 197. And we're seeing corporates obviously changing their behaviour, their voluntary net zero commitments, and putting those commitments increasingly in contracts to enforce their net zero commitments through their supply chain and their sustainability commitments. So the question is, what does private international law do with this? What does international arbitration do with this? Can it work to help these goals, or does it need a little more philosophical rethinking, a bit more of an evolution? So where do we go from here? I think for international arbitration, and this body in particular, there are procedural opportunities which Jay's already said were identified in the 2019 ICC report. Those are the procedural opportunities. What the ICC didn't do is look at the substantive issues. It didn't consider the philosophical question whether the insulation afforded by the international arbitration legal framework, that blueprint created in the 1920s to protect trade post-imperialism, it didn't look at whether that system is able to continue as is, business as usual, without undermining the climate change goals. And there's a substantive issue that lies at the heart of this. If international arbitration awards are issued and taken to national courts for enforcement, if those awards, if the enforcing court considers an award to be inconsistent with the commitments of that enforcing state under the Paris Agreement, is there not a conflict of public international law norms? And how are they resolved? Now, you might think there's a public policy exception under the New York Convention. Yes, there is, but it's been read very, very, very narrowly. But there are some answers to this, but these are the sorts of questions that perhaps the wealth of knowledge in the UNCITRAL body could explore more deeply. So, does the model law sufficiently permit review of awards that undermine climate goals? So implementation of the New York Convention, Article 5, is that trumping the Paris Agreement at present into the future? Do the UNCITRAL model rules sufficiently accommodate the procedural findings in the ICC report? And could UNCITRAL proactively implement the Paris Agreements with agreement with specialised dispute resolution systems? And we might get time to talk about that later, for example, through digital contracts or in relation to voluntary carbon markets.
Thank you, Wendy. I think especially for reminding us that we're not discussing dispute resolution mechanisms as an objective itself. We're discussing dispute resolution as a means to achieve net zero, and that is in the context of we're having this panel. And thank you also for giving us a historical perspective of possibly mirroring what we have been able to develop in the arbitration field in the realm of climate change and environmental law. But I'm guessing that you're not suggesting that it should take 60 years to develop the same framework that we have developed in the arbitration framework. And that's probably the question that I'll pose to you on how to expedite that in maybe in the Q&A discussions. Next, we'll have a video played. A speaker from Aisha who will be providing us an African perspective, the challenges it faces, and how enhanced transparency and third-party funding may contribute to climate justice for African communities. If the organizers can play the video for us, that would be great. Thank you.
Good afternoon. My presentation today is Promoting Climate Justice for African Communities. Climate change is the greatest threat facing humanity. However, we all experience it differently. I will highlight some of the unique challenges faced by Africans as a result of climate change. I will then make a case for climate justice for African communities. Building on the work of the UNCITRAL working groups, I will talk about how transparency and third-party funding can enhance climate justice for African communities. Climate change poses unique challenges for Africa. Africa emits the least amount of global emissions, some 2 to 3%, and yet it is the most vulnerable to the impacts of climate change. A 2022 report by the World Meteorological Organization indicates that some 108 to 116 million people in Africa are expected to be exposed to sea level rise risk by 2030. In addition, high water stress is estimated to affect about 250 million people on the continent and to displace up to 700 million people by 2030. At least 1 in 5 Africans goes to bed hungry, and an estimated 140 million people in Africa face acute food insecurity due to climate change. For this reason, UNEP estimates that a warming of 2 degrees C will threaten more than half of the continent's population with malnutrition. As for children, UNICEF has reported that climate-induced conflicts in the Sahel region have exposed about 10 million children to hostilities and insecurity. There have been 1,700 natural disasters reported between 1970 and 2019 in Africa, causing over 1 million deaths. While African people and communities are the victims of climate and weather-related disasters, they are not involved in negotiations of international treaties that spell out climate change obligations, as this is undertaken on their behalf by their governments. Also, they are not involved in investor-state disputes. Given the adverse effects of climate change on the African people, there is a need for them to attain climate justice by being included in climate justice efforts and initiatives. As Martin Luther King said, "An injustice anywhere is a threat to justice everywhere." But what do we mean by climate justice? There are many definitions, but one definition I particularly like is the IBA Task Force on Climate Change Justice and Human Rights. According to the task force, climate justice involves ensuring that individuals and communities have substantive legal and procedural rights relating to the enjoyment of a safe, clean, healthy, and sustainable environment, as well as the means to enforce this right in judicial systems nationally, regionally, and internationally. Climate justice acknowledges that climate change unduly affects people or communities that are less capable of preventing, adapting to, or responding to the negative impacts of climate change. In a bid to promote and improve climate justice for Africans, I will discuss the role that UNCITRAL can play in reforming climate change disputes. I will focus on two aspects, namely third-party funding and transparency. UNCITRAL has a key role to play in reforming third-party funding. Currently, Working Group 3 has explored the possibility of prohibition, permission, and regulation of third-party funding in investor-state dispute settlement. Third-party funding basically means any provision of direct and indirect funding or equivalent support to a party to a dispute, a funded party, by a natural or legal person who is not themselves a party to the proceedings, a third-party funder. This is in return for remuneration dependent on the outcome of the proceeding. Third-party funding usually covers all or part of the costs of the proceedings, such as legal fees and expert fees. Working Group 3 has discussed and proposed draft provision E on third-party funding and dissected various regulatory options, such as the prohibition model, the permissive model, and the restrictive model. I am particularly interested in the restrictive model, as this may assist African communities in particular. This option would be to prohibit third-party funding except in certain circumstances, namely access to justice and sustainable development exception models. Under the access to justice exception, third-party funding is prohibited unless the claimant demonstrates that he is not in a position to pursue the claim without third-party funding. For sustainable development, the third-party funding is prohibited unless the claimant demonstrates that its investment is in compliance with the applicable sustainable development options. While Working Group 3's efforts are commendable in this area, the existing third-party funding proposals are limited to investor-state disputes. The Working Group should consider proposing a model for third-party funding across all types of disputes. A model law that governs third-party funding will be instrumental in guiding states, especially African countries. At present, only 3 African countries, South Africa, Sierra Leone, and recently Nigeria, regulate third-party funding. Now, climate change disputes are expensive and take years to bring forward. The lack of funds incapacitates African and local communities from suing corporations and governments for emissions and fossil fuel policies. Third-party funding presents opportunities to enhance access to climate justice by facilitating and empowering people in African countries to hold their governments accountable in the fight against climate change. However, without a guide as to how a framework permitting and regulating third-party funding can be implemented, many Africans and their countries would remain ignorant about the benefits presented by third-party funding in enforcing climate change obligations. Building on the access to justice and sustainable development regulation models, Working Group 3 can consider the drafting of a model law on third-party funding, as this will accelerate the fight against climate change by equipping Africans with funds to hold their governments, investors, and private companies accountable. Despite this, there would remain practical challenges in getting third-party funders for climate change disputes, owing to their uncertain nature and unpredictable chances of success. Lastly, there may arise issues of unfairness where the distribution of damages must be shared between the local community that has suffered loss and the third-party funder. I will now move to the role that UNCITRAL can play in promoting transparency and propose that more can be done in this area. At its 43rd session in 2010, UNCITRAL entrusted Working Group 2 the task of preparing a legal standard on transparency in treaty-based investor-state arbitration. In 2013, the Commission adopted the UNCITRAL Rules on Transparency in Treaty-Based Investor-State Arbitration, together with the UNCITRAL Arbitration Rules. These rules were adopted by the UN General Assembly at its 60th plenary meeting in 2013. The rules on transparency recognize that investor-state disputes attract public interest because taxpayer funds are used to facilitate the legal and arbitration costs and to pay damages. While the rules on transparency make a commendable effort in this area and increase accountability and promote good governance, they apply only to investor-state disputes. This creates a gap for invoking transparency in climate change disputes arising from private party contracts and renewable energy projects. Another gap exists because there is no harmonized standard for reporting on emissions by corporations, government agencies, and investors. There is a non-binding greenhouse gas reporting standard. However, this is voluntary. This makes it hard for African communities to keep track of emissions released into their atmosphere. Furthermore, under the tenets of international arbitration, the privacy of the parties conflicts with the public interest and the disclosure of information that aids public participation. In private contractual contracts, it is almost impossible for Africans to find out more about the emissions estimated from a specific project. As a matter of principle, transparency demands that local communities are given access to information in order to participate in climate change litigation and to share their own experiences. This can in turn greatly assist courts, tribunals, and international courts in making appropriate decisions that hold governments, companies, and investors accountable for their emissions and their failure to fulfill climate mitigation and transition commitments. African communities cannot participate without access to information. Transparency in climate change disputes would spark more debate, promote public participation, and increase public pressure on governments to meet climate financing, climate transition, and mitigation commitments. UNCITRAL Working Group 2 could consider coming up with model transparency rules applying across all disputes. These rules can be used in climate change disputes and adopted into the national laws of various countries. Transparency is at the core of the fight against climate change. Without this, there is no access to information, and without access to information, there can be no climate justice. To conclude, African communities are not financially supported currently to lodge claims against their governments, investors, and corporations. They will continue to remain incapacitated to hold climate-unfriendly investments accountable. Third-party funding, if carefully regulated, can present numerous opportunities for enhancing climate justice. Regulation will require guidance from a model law drafted by UNCITRAL. Even with third-party funding, there is still a need for transparency and disclosure of emissions records by corporations and governments, as well as ensuring access to information and the participation of local communities. Here, UNCITRAL again has a role to play by drafting a model law governing transparency in all disputes. We should remember that Africa is at the forefront of the climate crisis and may be key to the ultimate solution. The fight against climate change requires that no one is left behind. Africa cannot be left behind. Thank you.
Thank you, Aisha, for sharing your perspectives. To be clear, the transparency rules have been prepared in the context of treaty-based investor-state arbitration, and I think the proposal from Aisha is that we may wish to maybe broaden that scope to other types of disputes. That is one point. And the discussions in Working Group 3 has been focusing on the use of third-party funding by investors to raise claims, but possibly having that mechanism somehow applied to other disputes, climate change disputes, may be useful in giving access to climate justice for the African communities. So there may be some questions from the floor to her, but without further ado, I would like to turn to our third speaker, Ms. Annette Magnussen, who will touch upon the different means to resolve this climate change disputes, more specifically, how mediation could be useful in resolving climate change disputes. Annette, you have the floor.
Thank you very much. And I will begin with the observation that commercial disputes will be an increasing element of the climate transition going forward. And I will soon explain why that is. We have heard Wendy talk about the success story of international arbitration and the leading role that UNCITRAL has played in this development. And I think we should never underestimate the power of the instruments put forth by UNCITRAL and the harmonization success that UNCITRAL has produced since its inception. UNCITRAL has played an instrumental role for general international developments, as we have heard, including also in relations between states. As I was preparing these notes, what came to my mind was a book that we produced in Stockholm some years ago on the occasion of the centennial of the SSC Arbitration Institute in Stockholm, Arbitrating for Peace, How Arbitration Made a Difference. And I actually have two of the authors up here with me, with Wendy and Anna, both having submitted chapters to this publication. And the book includes examples of difficult geopolitical conflicts which were actually resolved using the UNCITRAL arbitration rules in contexts where there seemed to be unsurmountable difficulties in resolving the conflict. And again, here, the harmonized and generally accepted rules from UNCITRAL made a pathway to be able to resolve the conflicts. So this is just to illustrate how powerful the generally accepted principles as decided in this room have been. And I do think that the strong global footprint demonstrated by the work of UNCITRAL can play an instrumental role to contribute to climate change mitigation and adaptation, including when it comes to climate change disputes. The climate transition requires the transition of societies, and the Intergovernmental Panel on Climate Change, the IPCC, gives us an idea of what can happen ahead for this to happen. Working Group 2 from the IPCC, which published a report from last year, and Working Group 2, I should explain, focus on impacts, adaptation, and vulnerability as a result of the climate crisis. And this could also be rephrased as, how bad is the problem? The Working Group 2 from IPCC states that key infrastructure systems will be increasingly vulnerable. The costs for maintenance and reconstruction of urban infrastructure, including building, transportation, and energy, will increase with global warming levels. Weather and climate extremes, says the IPCC, and this is something we have all been witnessing, they are causing economic and societal impacts across national boundaries through supply chains, markets, and natural resource flows, with increasing transboundary risks projected across the water, energy, and food sectors. So avoiding climate risk requires urgent decision-making for the new built environment, but also retrofitting of existing urban design, infrastructure, and land use, says the IPCC. If we turn to the International Energy Agency, already alluded to by Wendy, and their roadmap to reach net zero by 2050, and they have different pathways on how we should reach net zero by 2050 and reach and be within the target set by the Paris Agreement. The IEA states that reaching net zero by 2050 will require the immediate and massive deployment of all available clean and efficient energy technologies, combined with a major global push to accelerate innovation. And under a scenario to reach net zero by 2050, clean energy investments needs to be 4 times higher than it is today. And we have even higher numbers. We heard the number $6 trillion being mentioned. And today it's about slightly over $1.3 trillion US dollars annually in these investment spheres. So it needs to massively increase. We know that commercial disputes with climate change elements are already happening, but we only have a glimpse of the numbers. We heard reference to the ICC report on climate change disputes, and as was pointed out, this report focuses primarily on procedural issues and not substantive issues. There are some references to substantive issues in the report, but not very many details on what kinds of disputes and the contents of the disputes when it comes to commercial disputes that has been reported or seen at the international arbitral institutions around the world. But this was an issue that was surveyed as part of the study for the ICC report. But again, that was not the main objective of the study. The SEC Arbitration Institute in Stockholm has looked at this issue twice and published 2 reports on the issue, and looking at the green technology dispute. So that's sort of being the umbrella concept of disputes relating to the climate change transition, relating to green technology. The first report was published in 2019, and in this report we can find examples of commercial disputes relating to sustainable forestry, organic food, organic waste management, and carbon reduction technologies. So a second edition of this report was published last year, and it was interesting to note 2 things. First, that the number of so-called green technology disputes in Stockholm had increased, and also that the share of parties involved in these disputes that have carbon reduction as their main business activity had also increased as part of these commercial cases. So the ICC and the SEC reports, again, they are just mere glimpses of what we're seeing in the commercial sphere. And if I could have one wish, it would be that other commercial arbitral institutions would do similar studies so we can get a better understanding of what is going on in the commercial cases when it comes to climate change transition. But more commercial disputes, we know this, more commercial disputes could be expected ahead. And the share of climate change-related disputes in the commercial caseload at arbitral institutions, not least, could be expected to increase. And why is this? And here I come back to what I said at the beginning, that commercial disputes will be an increasing element of the climate change transition. And this is because the climate transition is also a recipe for disputes. Going back to what the International Energy Agency said in the roadmap to net zero by 2050, the IEA notes that almost half of the reductions necessary to reach net zero by 2050 will come from technologies that are currently only at the demonstration or prototype phase. Reaching net zero by 2050 requires a rapid deployment not only of available technologies, but also the widespread use of new technologies not yet on the market. It will require a rapid acceleration of clean energy innovation, accelerating the rollout of demonstration projects, and leveraging the private investments in research and development. IPCC Working Group 3, so after Working Group 2 has described how bad is the problem, Working Group 3 of IPCC says, or it describes how do we fix it. In their report from last year, they note that the increasing importance of the private domain for mitigation and adaptation initiatives. This is where much of this work will happen. But also that this transition will be characterized as disorderly, in lack of an effective central governance. And it will leave many coordination processes as a result of the transition to be navigated by individual companies or institutions and by civil society. So identifying a lack of a general governance framework for much of this development in the private sector. This is why the climate transition is a recipe for commercial disputes. Because as we have learned, this path towards the Paris Agreement targets and net zero by 2050 will entail a societal transition that involves, again, new technology deployed in an environment of new and at times shifting policy. There will be new actors. Some of them will be quite inexperienced on new markets, and all of this needs to happen at a very high speed. So I have worked 25 years in international disputes, and for slightly over a decade, I was heading an arbitral institution with a fair number of commercial cases on an annual basis. So I can tell with certainty that what I just said, new technology, new actors, shifting policy, high speed, this is a recipe for commercial disputes. And in this environment, mediation, in my mind, should become the number one option when it comes to dispute resolution strategies. And I believe that the scenario that I just described leverages the importance of mediation, and also leverages the importance of the UNCITRAL instruments in this space. So we have the UNCITRAL mediation rules and the Singapore Convention. The list of the advantages of mediation is quite long, and I'm sure many in this room are quite familiar with what the advantages of mediation. So mediation enables the preservation of commercial relationships. It enables a look into the future and planning of new endeavors and planning of a prosperous continued business rather than looking back and see what went wrong in the past and focusing on what happened last week or last year. It has an element of flexibility, and it has speed. It is faster. All of these are factors which can also facilitate the climate transition. As we learned, projects need to be deployed fast. New technology needs to be rolled out. We cannot stop just because there is a slight hiccup along the way. Just solve the problem, get on with it, launch the new technology, contribute to the transition of society. And you can do this in a short time frame, and this is what mediation will offer you. So mediation, therefore, has an extra important role to play to support the developments under the Paris Agreement, and also, in the end, that we will be able to maintain within the planetary boundaries. Time is of the essence when it comes to concluding the contracts we need for the climate transition, and is also time is of the essence to finish the projects, to finish the new technologies, to get them on the market for climate change efforts. This is why mediation should be a starting point in any discussion on dispute resolution strategies for any new climate change-related dispute in a commercial setting. So, in summary then, commercial disputes will be an increasing element of the climate transition. Resolving a substantial share of these disputes through mediation may support a faster deployment of new technologies and policies, and in the long run, a society within the planetary boundaries. We know from experience that proposing mediation once a dispute has erupted could be a sensitive issue. From the party wishing to propose it, it could be perceived as maybe that would be a demonstration of weakness. However, internationally accepted and strong legal frameworks may contribute to making a proposal for mediation more mainstream, to lower the hurdles for the use of mediation. Therefore, we should support internationally accepted standards and models that presupposes the use of mediation. And we may, in this room, want to give some thoughts on how additional tools can be developed to support the use of mediation, in particular then in the climate change-related context. Because I believe that in leveraging the use of mediation, the UNCITRAL instruments may in a very concrete manner contribute to the goals of the Paris Agreement, as societies seek to combat, mitigate, and adapt to climate change. Thank you.
Thank you, Annette. I think we agree that we need to further promote the use of mediations, and last week the Commission has adopted texts on the use of mediations for resolving investor disputes. So I think that is one aspect of it. I just wanted to also highlight that when you're talking about green technology and technology-related disputes that arise from climate change, Working Group 2 is working on developing a set of model clauses which can be used for technology-related disputes, and therefore there may be some synergies between what Working Group 2 is working on, which is also to provide more efficient and even a quicker resolution for technology-related disputes, which may relate to climate change disputes. So I think there is something that Working Group 2 may also help and assist in resolving these disputes, which we can touch upon. Our last speaker is Mr. Tomoko Ishikawa, who will touch upon corporate responsibility to climate change, and such being the legal basis for counterclaims in ISDS contexts. As I mentioned, this is something that Working Group 3 is also looking into, on the causations on how to raise counterclaims. And of course, we will be addressing this in the next paper that will be addressing procedural issues and cross-cutting issues. Can we have the video from Professor Ishikawa?
Hello, I'm Tomoko Ishikawa. It is a pleasure to be part of this panel session. My presentation discusses climate change and investor-state dispute settlement, or ISDS, with a focus on the topic of counterclaims based on the investor's climate change responsibility. States face increasing pressure to take more stringent climate mitigation measures. At this year's G7 ministers meeting, G7 countries for the first time expressed their commitment to accelerate the phase-out of unabated fossil fuels, including gas and oil. At the same time, the phasing out of fossil fuels may impact the interest of foreign investors. If there is an applicable investment treaty, they might challenge the phase-out through investment arbitration, arguing that, for example, it constitutes indirect expropriation. There are concerns over the negative impact of ISDS over the climate change measures. For example, scholars argue that investment arbitration may affect the distribution of costs and risks under negotiated transitional arrangements. This concern has impacted the recent investment treaty practice, notably dissatisfaction with the soft opt-in rather than total exclusion of fossil fuel investments from the modernized Energy Charter Treaty will likely lead to a coordinated withdrawal of EU, Euratom, and member states from the treaty. Meanwhile, outside the investment treaty regime, corporate climate change responsibility has been asserted in climate change litigations. There are good reasons for holding certain corporations responsible for greenhouse gas emissions. First, the impact of the decisions and activities of certain companies in the carbon industry on climate change is no smaller than that of states' climate policies. Secondly, these companies have profited most from the delay in climate change action. Thirdly, they may ultimately impose some of the climate change liability cost on consumers through the price mechanism. Fourthly, corporations are arguably better bearers of responsibility as they have the knowledge and technologies to develop alternative ways to reduce greenhouse gas emissions. In addition, climate change is now widely recognized as a human rights issue. We also witnessed a recent legal development in certain jurisdictions to codify corporate due diligence obligations in the global supply chain. These developments suggest that climate actions against corporations are predicted to increase. With this background, defendant states' counterclaims based on the investor's climate responsibility in investor-state disputes started to attract attention. Given the one-sided nature of ISDS, that is, only investors can file claims against states and not vice versa, raising counterclaims remains the only way for the state to raise claims against the investor in such proceedings. There are benefits for counterclaims based on the investor's climate responsibility. The possibility of facing counterclaims may well shift the claimant investor's cost-benefit analysis towards more prudency in processing the claims. Climate change counterclaims is a way to keep ISDS aligned with future developments in jurisprudence concerning corporate climate change obligations. Despite the benefits of climate change counterclaims in ISDS, there are challenges such claims will face in practice. Before discussing these challenges, I would like to clarify the content and the possible legal basis of climate change counterclaims. Given that the state itself has the regulatory power to impose, implement, and enforce standards of climate mitigation, it would not seek injunctions to ensure climate change mitigation against corporations, but seek monetary claims. With regard to the state's monetary claim, if the domestic law framework of the host state provides fines for a violation of climate change-related obligations, this may provide a ground for such claim. Likewise, if the host state has executed contractual or other arrangements with the investor that includes the latter's climate change obligations, it may pursue monetary claims under such arrangements. However, in the absence of such domestic monetary sanctions mechanisms or contractual arrangements, what the host state claims would be monetary compensation for the damage associated with climate change. Possible damage includes the cost of relocation or of taking appropriate safety measures incurred by slow onset events such as glacier melting, damage incurred as a result of extreme weather events such as floods, and pure environmental damage. A question to follow is what would constitute legal grounds for such claims. In domestic climate change litigation against corporations, claims are generally based on domestic tort law. There is as yet no international law that provides climate change obligations binding private entities, and therefore domestic law remains the only direct path through which corporate climate change obligations can be pursued. We may recall that in Mir Defensi versus Royal Dutch Shell, Shell's obligation to reduce CO2 emissions was found to exist under the Dutch law on tort, although international soft law on corporate human rights due diligence did inform the court's interpretation of the civil code. Although there are controversies over the application of the domestic law in investment arbitration, I have argued elsewhere that the unavoidable interaction between international law and domestic law in ISDS should justify the application of most domestic law as a basis of counterclaims. Now I come back to the issue of challenges for the counterclaim. Particularly, a counterclaim must meet the jurisdictional and admissibility requirements. For example, Article 46 of the ICSID Convention provides the following conditions for admission of ancillary claims. A. They arise directly out of the subject matter of the dispute. B. They are within the scope of the consent of the parties. C. They are otherwise within the jurisdiction of the center. The second and third requirements are the conditions for jurisdiction. They do involve unsettled questions which have resulted in the dismissal of counterclaims at the jurisdictional phase. I think the UNCITRAL may play an important role in addressing these questions. However, in today's presentation, I would like to address the requirement of connection between the principal claim and the counterclaim.
ولكنني اليوم سأتطرق إلى شرط العلاقة أو الصلة القائم بشأن العلاقة القانونية بين الأطراف المعنية باتفاقات الاستثمارات وهي مرتبطة بالدعاوى المضادة الخاصة.
The question with regard to the connection requirement is whether this requires a legal relationship between the invoked investment treaty obligations and the legal grounds of the counterclaim. Requiring legal connection would foreclose the possibility of raising climate change counterclaims based on domestic laws that belong to a different legal order from international law. However, the rationale of counterclaims is to serve procedural economy, finality, and consistency by solving the dispute as a whole in a single proceeding. These objectives can be achieved only by finding the admissibility of counterclaims that have a factual connection with the principal claim. The next question is the quality of the connection, that is, what factual connection would justify the admission of the counterclaim. This is where a counterclaim based on corporate climate change responsibility faces a particularly difficult challenge. The case law suggests that the sufficiency of the connection requires an assessment of the relationship between the facts forming the basis of the counterclaim and those of the principal claim in terms of location, time, and the parties. As I noted, in most cases, a host state's climate change counterclaims will be the claim for monetary compensation for the harm incurred in relation to climate change. In this context, the following factors should be taken into account in the determination of the existence or absence of the sufficient connection. First, the claimant investor's climate responsibility must be established in relation to the investment that is the object of the principal claim. Therefore, the fact that, for example, the claimant investor has a large share of global greenhouse gas emissions does not, in itself, establish the required connection. Secondly, since effects on climate change are by nature long-term and indirect, temporal proximity would not be a required condition to establish the connection. Thirdly, given the cumulative nature of climate change effects, locational proximity between the alleged climate change related damage and the investment is not required. So, to sum up, while a more flexible understanding of temporal and locational proximity is appropriate in the context of climate change counterclaim, the alleged climate responsibility of the investor must still be connected to the investment that is the object of the principal claim. This gives rise to another layer of challenges at the merit stage in establishing causation, which is already one of the biggest hurdles for climate change tort claims. Since it is scientifically impossible to prove that the emission released by a particular actor from specified projects at a given time directly caused the alleged damages, the case law has required the following causal relationship. First, a link between a slow onset or extreme weather event and climate change. Secondly, a link between a specific loss and that change or event. Third, a link between the defendant's conduct and climate change and identifying the defendant's relative contribution to the harm. The threshold for a sufficient contribution to establish causation varies between jurisdictions and between each case. That said, it is scientifically possible to estimate standard greenhouse gas emissions from a specific source. Legal causation between source-specific greenhouse gas emissions and climate change was recognized in a case called Gloucester Resources Limited. This is a case which was not filed against a corporation, but was actually filed by a mining company challenging the Australian authorities' denial of its application for a coal mine project. In this case, the environmental impact statement had estimated scopes 1 to 3 greenhouse gas emissions from the project. On this basis, the court acknowledged a causal link between the project's cumulative greenhouse gas emissions and climate change. These cases do indicate that courts of certain countries started to demonstrate the willingness to accept a causal link between entity-specific and source-specific greenhouse gas emissions on the one hand, and certain possible consequences of climate change on the other. Despite this, seeking monetary compensation on the basis of corporate climate change responsibility is extremely challenging. Moreover, the amount of the pro rata compensation will be very limited, and this is even more so for climate change counterclaims. Therefore, the financial benefits of counterclaims will be highly limited. However, it may serve non-financial objectives. It allows arbitration tribunals to incorporate climate change concerns into dispute resolution. This may in turn address concerns about the negative impact of investor-state dispute settlement on climate change. Most importantly, it may serve as a way to pressurize corporations through an international forum to reduce their greenhouse gas emissions and thereby further enhance the notion of corporate climate responsibility. That is all from me. Thank you very much.
Thank you, Tomoko, for highlighting one of the aspects that arise in climate change dispute resolutions and possibly the difficulties that states face in raising counterclaims and possibly getting any damages for it. And as indicated in my introductory remarks, I think the audience have been able to observe the wide spectrum of disputes that could arise with regard to climate change, which involves different parties, different subject of the disputes, and different forms. And we've touched upon ISDS, we've touched upon commercial disputes, we've touched upon cases in domestic courts. But of course, we have not been touching any possible disputes between states with regard to climate change-related measures or harms caused by a state to another state because they have not performed their international obligations under treaties. Now, whereas work could start to categorize the different types of disputes and the different parties involved that may be involved in climate change dispute resolution to better define the possible scope of work, I believe that the Commission would need to first have a better understanding of what the objectives of such work should be. A dispute is, in most cases, about the rights and obligations of the parties that are involved in the disputes. And as Angelo mentioned in the opening remarks today, it is unlikely that the Commission would embark on work to create new obligations, which could form the basis of a dispute. Rather, it may be necessary for the Commission to look at where the rights and obligations of the disputing parties are. Are they arising from contracts? If they do, they may not be so different from any other commercial disputes that we have, which could be resolved through the existing framework. Or is there something else? Are there disputes arising from compliance measures, or because of non-compliance with ESG standards, or because of corporate social responsibilities? Or is the multi-party aspect to it that actually raises the need for UNCITRAL to embark on work in this area? So my first question to the speakers, we have about 25 minutes of Q&A, to the speakers is, what is that something that requires the attention of the Commission in this area? I ask in the sense that UNCITRAL has tried to preserve the generic nature of its UNCITRAL text so that they can apply to all disputes, regardless of the type of disputes and the parties involved. So what is so specific about climate change disputes that require a distinct approach? What is currently lacking in the current framework, and what kind of work could UNCITRAL embark on? Now, the last question is a little bit on the form. Would such work be addressed to the parties to the climate change disputes? Would it be addressed to the legislators that would enact laws that govern such disputes? Or would it be addressed to adjudicators or maybe mediators that handle such disputes so that they have the climate change considerations in their mind? So with that, I'd like to actually go back in the order and give the floor to Tomoko, who is live. Tomoko, would you be able to answer those questions?
Okay. Thank you, Joe. In my presentation, I discussed the challenges that the current ISDS regime poses for climate change litigation, climate change counterclaims. So UNCITRAL does play an important role in addressing these challenges. So we should recall that the working group proposed a draft provision on counterclaims. And interestingly, the draft provision expands the scope of counterclaims by allowing counterclaims based on any breach by the claimant investor of its obligations, which do not need to be linked to the principal claim. I think this is a product of innovative thinking and can provide a straightforward solution to the challenges arising from the connection requirement I just described. But that said, to my view, caution should be paid to this approach. This is because this approach does not necessarily align with the fundamental rationale of counterclaims, which is to serve judicial economy and efficiency. Allowing counterclaims that are not linked to the principal claim can broaden the scope of the dispute to an unexpected extent, resulting in higher costs and longer duration of proceedings. That said, on the other hand, providing the host state's right to counterclaims, as this draft provision does, is certainly a desirable reform option, considering the current uncertainty surrounding the jurisdiction and admissibility of counterclaims. Likewise, it is certainly advisable to promote the inclusion of investors' climate change obligations with respect to its investment activities in investment treaties. This inclusion would establish a clear ground for their corporation's climate change accountability through counterclaims. In this case, the investment treaty should also provide secondary rules that determine the consequences of a breach of such obligations to provide a ground of remedy. So ultimately, I think that the UNCITRAL's important role in this context is to convey a clear message that the system acknowledges the concept of reciprocity of obligations and the notion of responsible investment, which encompasses climate change responsibility. And in this sense, this message should be addressed to not only the participant of the regime, but also the audience of the regime, including the civil society. Thank you very much.
Thank you, Tomoko. Annette?
Thank you. The UNCITRAL instruments, they are many different levels. So you have the convention, you have the rules, you have model laws, and then you have instruments, for example, like the notes on organizing arbitral proceedings. And I think if there was a way forward to, like I said, enhance the use of mediation in a context where that would support a swift development towards a climate change transition, I think that would be fantastic. And just to give you a concrete example, in most corporations, I believe that if you have a dispute resolution policy, if it's a corporation of size, that will be clearly divided from any climate policy that has been adopted by the corporation. They live sort of separate lives. I think it would be fantastic if those they would be aligned, but where the climate dispute resolution policy would include elements, for example, on the use of certain tools for dispute resolution that clearly supports the climate targets of the individual corporation. And for example, if there would be an instrument of some sorts, and again, that could be a fairly soft law instruments, but some sorts that would support that alignment between dispute resolution policies and the climate policies of the individual corporations. So I think that would be my idea, throwing out there. And second, I would like to sort of align with Aisha was talking about transparency. And this is an issue that I have also been thinking about quite a lot, primarily in the commercial dispute context. And which was what Aisha said as well, but also she talked about the public participation, which is important. But the way we have been talking about it is sort of, again, as a method of enhancing this technology shift. So I mentioned all of this new technology that needs to be deployed at very large scale, and all the difficulties associated with this, all these new ideas that needs to be tested, all of these innovations that are currently now being figured out in someone's garage and somehow can help us solve the climate crisis in some places in the world. There will be problems, of course, as these projects are being deployed, and there will be disputes, as I just pointed out. What if we could also, in addition to using mediation to resolve them faster, what if we could also agree that, okay, the lessons we learned, how this innovation works or did not work, or how this policy worked or did not work, what if we could find a way to share that experience and that knowledge with the greater community rather than just the individual corporations and actors involved in that specific project? And my favorite example of how that has served humanity was when Röntgen, when he had discovered the X-rays, he decided not to patent that because he realized this is something that would serve the greater good in humanity. What if we could apply a similar way of thinking in a commercial setting for the lessons learned as we try to make this massive societal transition to have a low-carbon society? And the way to do that, for example, and we have heard many calls for the but one way of doing that could be to have somehow, a model clause where the parties agree to, in one way or the other, share experiences. The level of transparency in a commercial dispute setting that relates to the climate transition. That is another challenge I offer to the UNCITRAL community. Thank you.
Thank you. Aisha?
Thank you. I had already given my proposals in terms of making the work of the two working groups 2 and 3, expanding them to cover more generic disputes in terms of transparency and third-party funding. But what I wanted to maybe touch on, which is slightly different, is that besides the reforms required that have already been mentioned by Professor Tomoko for ISDS, we really do need to look at the international legal framework because it doesn't currently enable African regional blocs to bring claims related to climate change. And it's very difficult for individual states to show causation or to show that damage is limited to them. So I had some proposals there about how, for example, the ICJ statute could be amended to allow disputes to be submitted by a group or a coalition of states, because climate change is a cross-border issue by its very nature. And this type of amendment would facilitate sort of not really class claims, but claims across various states for historical emissions. And the reason that this is an important development is because one of the challenges we face with addressing climate change is the fact that states are not meeting their financial commitments under the Paris Agreement. And because the developing countries like African states don't actually have the resources currently to make any adjustments or adaptations. In fact, they're facing far more pressing problems because there's a huge energy gap and 50% of Africans don't have access to electricity. So you can't talk in Africa about a transition when there isn't sufficient electricity to transition from. So I think my proposal would be, by all means, UNCITRAL can continue with its working groups. But I think as an international legal community, we have to think very carefully about how the international system must be changed to facilitate climate change reparations, which would supplement the climate financing required. Thank you.
Thank you, Aisha. I have a more specific questions to Wendy. Because yesterday we were discussing the legal nature of voluntary carbon credits in voluntary credit markets, referred to as a bund of contracts and the legal uncertainty that we face there. Which leads me to believe that there are certain disputes that arise in the voluntary credit market. Could you elaborate? I mean, I know that we have a little bit of running out of time, but could you elaborate on what kind of disputes arise in the current practice and whether this is something that we should look into? You have 2 minutes, please.
So start with the bathtub, one carbon budget. So what you're trying to do with every single carbon removal, whether it's a compliance, whether it's an Article 6, whether it's a voluntary carbon markets, is reduce that excess carbon emissions. So that's where the core carbon principles, our keynote speaker yesterday, Annette Nazareth, chairs the Integrity Council for the Voluntary Carbon Markets. Those core carbon principles feed down the entire life cycle of a single carbon unit if they are to govern, if they become the thing that governs all, or something like those. Those core carbon principles are about the integrity of the creation of the project that leads to the offset and broader integrity above effective carbon removals, but also protection of human rights, indigenous lands, environment, more broad protection and integrity. The Integrity Council will decide whether or not the VERAs, the gold standards, the ISOs, the standard setters have appropriate standards and procedures for approving project accreditors. So the folks who will approve a project or not to create a unit. Between the core carbon principle governance body and the standard setters, there's a decision. Do you comply with our core carbon principles or not? Yes or no? If the answer is no, the gold standard, the VERA, might want to review that decision, whether that's a contractual right or whether it's some form of other right. They will want to review that decision if it goes against them. and have the ICVCM judge and jury over its own decision-making doesn't sound objectively fair. Then the standard setter then will have a contractual relationship with the project accreditor. This is just a straight line. There's lots of different sponsorship and funding agreements that exist within this. The project accreditor to the project owner or owners, and it might be an entire Indigenous community that owns a project, and then the project owner comes through. There's a sale and purchase agreement of that credit. It's the first transfer, and then there's multiple other transfers, which is where your ISDA agreements come in, where these are traded as commodities on the exchange. Every single one of those movements through that life cycle, through that process, and then you have retirement, through that process involves a relational contract or a relational transaction. And any one of those could give rise to a dispute. What I think is the whole body, the whole ecosystem, and I just took the baseline, there's a bunch of different contracts in there. The whole system needs to be interpreted, applied, and enforced in accordance with that baseline integrity standards sort of minimum. And in order to do that, you can't have what we have now, which is any old arbitrator, and trust me, I am any old arbitrator, deciding any one of these disputes as they come up. You need somebody who understands the UNFCCC, the Paris Agreement, the IPCC reports, and the broader purpose of carbon removals, and needs someone who understands the core carbon principles and understands what that integrity means through that life cycle. So I think there is room for a model arbitration or other dispute resolution agreement with tweaks. And the tweaks could be that you have a standing tribunal. I'm starting to sound like a multilateral investment court now. But you have a standing tribunal, a group of people who take the time, who make the effort to learn about this very, very, very complex subject that we spent yesterday talking about and left me more confused. So it's difficult. So people who understand it, and then you appoint from there, but also that's quick. So you have a level for an expert determination that's fast and dirty with an appeal to a binding body. It's been done before. The ICANN, the Internet Corporation for Assigned Names and Numbers, the top-level domain names, your .sport, .charity, .church, don't know if that's one, they do exactly this from their industry multi-stakeholder group all the way through those contracts. So there is precedent. It's been done before, but I think that would be an innovation that would be worth exploring in carbon markets. I'm sorry, Jay, I know you'd want me to stop, but if you did it really, really, really well, perhaps Philip and the UNFCCC and the Article 6 folks would adopt the same body for the implementation and enforcement of Article 6 transfers as well.
Thank you. I would like to collect a few questions from the floor and then actually go back to the speakers. So if there is anybody who wishes to take the floor, I know that I have one from Angelo. But Angelo, do you want to? Yeah, India, please.
I'd like to first thank the UNCITRAL and all the panels for the informative and illuminating discussions on important topics of climate change we've been having since yesterday, this morning, and now. These discussions have been thought-provoking. Now, we learned in the morning that currently there is no regulatory framework or policy on supply chain accountability. Now, in the absence of a regulation on supply chain accountability, there is a possibility for claimants to simultaneously prosecute manufacturers and supply chains for violation of climate laws in more than one jurisdiction. My question is, 1, how should such issue be tackled? 2, what would be the impact on enforcement in case of conflicting decisions?
Thank you. Since we're running out of time, I would like to collect all the questions and then pose those questions to the speakers. The distinguished representative, Côte d'Ivoire.
Microphone, please.
Ah oui, excusez-moi. Je vous remercie.
Thank you. My question is similar. generally within the mechanism, I've noticed that the interpreter apologizes. I would request the question to be repeated. You talked about financial compensation. It's limited. What mechanisms are in place in order to cover relations with investors?
The representative from Brazil.
Thank you, Mr. Moderator. This being the first time that I take the floor, allow me to start congratulating the Secretariat for the wonderful seminar you've put together for us. It's been a delight to follow it. You've packed so much information that we will be thinking about it for quite some time, so I commend you. We'll leave the policy aspects for the high-level panel that we will have later, in which Brazil will be represented at the level of HOD, so the investor will be here. But in terms of questions, and this is pretty much a stream of thought, so it's not as polished as it should be, I wonder if we could talk a little bit about the new kid on the block, which is adaptation, right? We will have the loss and damage fund, and we need to address the issue of causation. Loss and damage in relation to what? So even if we have, for instance, a model arbitration, this is an issue that would have to be a little bit thought about. And because extreme weather events are predicted to become far more common and more often, perhaps it would be useful to hear a little bit from the speakers about how do we plan for this stage. We're now discussing that companies will have to integrate these extreme weather events in their day-to-day planning. So their risk assessments will have to consider it as something regular. You're building a dam, you have to consider considerable rainy levels. So how do you see these causing the trends major in terms of having multiple claims, which are not necessarily class actions, but they are significant in terms of quantity, and some of them will be transnational. So congratulations again. Thank you very much.
Angelo?
Thank you, Jay. No, just two things that crossed my mind in discussion. One, listening to what Wendy, the link she made between public policy and enforcement of order and mainstreaming climate change into our arbitral decisions reminds me of a discussion we had at UNCITRAL back in the 90s about whether UNCITRAL should offer some recommendation or guidance on the scope for public policy. At that time, the Commission was rather conservative about that and thought that this is not for this body to pronounce itself on the interpretation of New York Convention, but we did that in respect of the form of the arbitral award, right, with the recommendation. And perhaps this is something that the Commission may wish to consider at a certain point, how climate change can be mainstreamed also into the world of arbitration, and whether or not could be a clear pronouncement that climate change considerations are a matter of public policy and may also entitle the local judiciary to consider them when consider the enforcement of a war. That's one topic. The second point, I think, also has to do with the various references to the exposure of host countries to investment claims for added costs borne by the private sector to implement compliant measures to comply with their NCDs or perhaps the banning of a technology, changes of technology that may happen over time. And just since part of what we're supposed to do is also to look at how our instruments deal with that currently, just to draw the attention also of the audience to the way the UNCITRAL legislative guide on PPPs, public-private partnerships, deals with those types of claims. There are contractual claims. The guide does not deal with investment claims. But on contractual claims, the parameter for compensation of private sector under PPP contract is if the regulatory change is discriminatory in nature. If all the regulatory change does is to introduce a measure that the entire business or that particular industry in the country, without discrimination of nationality, has to bear, that's to be considered just an ordinary commercial risk and ordinary cost increase, that if it's borne by the domestic investors, also to be borne by any foreign investment. So there is already here some thought that was given to how treat equitably and preserving the public interest in case of regulatory change to address matters of public policy. Thank you.
Thank you. I think the questions that we got addressed that while the panel was comprehensive, there are other types of disputes that may arise with regard to climate change. And having all of that packed into one might not be the necessary way forward. But with that, we are running out of time, but I'd like to give the speakers maybe 30 seconds each to respond to not all of the questions, but the questions that attracted you the most. Wendy, you're first this time.
Greatest hits to Côte d'Ivoire, to Asia, and perhaps to Brazil a little as well, is there is an arbitration clause in the Paris Agreement. And as I said earlier, only 3 states have opted into it. So in terms of state-to-state dispute, perhaps that's something that UNCITRAL could explore for these crossover issues that we're seeing, that states are wanting to bring claims in relation to other states on loss and damage in particular, maybe. In terms of Brazil, how to build into day-to-day planning, the insolvency working group could actually explore potentially looking at looking at funds like the financial stability funds we have in the UK, like the pension funds. So if you're operating in a high-emitting activity that's in a transition out, a state requiring to pay in a levy to pay for the cost of the decommissioning or the stranded asset disposal. So it's a cross-sectoral solutions for UNCITRAL. So not everything's a dispute resolution answer, but that insolvency. And then can I just say on the sorry, I was going to be quick. On the public policy, I actually think there's a better argument under the New York Convention for integrating or folding the Paris Agreement into the interpretation of the potentially conflicting rights between Paris and New York Convention, and it's governing law. Article 5 permits you, if the tribunal exceeds its mandate, excess of mandate may be failure to apply the governing law. And we've got myriad new climate laws coming in at domestic and international level, and soft law as well. And the arguments I've been making to enforcement courts, where I have an award that I don't think accords with Paris, is that the tribunal failed to apply the governing law. And my plea is the easy meat. I think the easy fruit to pick right now is to capacity build within states, in particular, in either investor-state disputes or mixed disputes involving a private investor and a state under contract, which is the most of them, to make sure that the states make these arguments, because the tribunals can only work with the arguments that are brought to them. And we've seen a masterclass in how states can coordinate with a single uniform argument and put in an intervening brief and regularized state respondent briefs in relation to the intra-EU issue on the primacy of EU law over investment law. We know that these pre-packed briefs can be managed in an extremely artful way. So why not take that model for the climate change issues?
That was more than 30 seconds. Aisha?
Sorry, I didn't have the benefits of the translation for one of the questions, but just touching on, well, I don't know if this was covered in the questions, but one of the proposals I think we need is to make better use of the United Nations General Assembly. Because we've seen that they have been able to have a group of nations, island nations, put forward a request to the ICJ for an advisory opinion on climate change obligations. This was in March 2023. And one of the questions they posed to the ICJ is, what are the legal consequences under the obligations for states where, by their acts and omissions, they have caused significant harm to the climate system and other parts of the environment with respect to one, states, including in particular small island developing states, which due to their geographical circumstances and level of development are specially affected or particularly vulnerable. I really like this type of approach because a number of African nations, Uganda, Sierra Leone, Mozambique, Angola, and Morocco, joined Vanuatu in bringing forward these draft legal questions. The General Assembly adopted them and put them forward. I think there are some mechanisms that we are not fully utilizing already to bring forward some of these issues. And I think as we do that, we need to think about creating new mechanisms. Thank you.
Thank you, Aisha. Annette?
Thank you. I will be very brief. So on the topic of adaptation, and speaking then from the lawyer's perspective, I think one element of adaptation, of course, is the adaptation of legal norms and statutory laws. And I think that is something that is what we're seeing, both at national but also at the international level. How do we interpret certain fundamental concepts, and also in view of the climate change crisis and the expectations one could have on, for example, certain obligations and certain elements of the law given the climate crisis. And I think we are only at the beginning of that, the shifting definitions of certain standards within both national law and international law. And some of that has been alluded to over these 2 days. So I think that's one part of the adaptation, in particular speaking from the lawyer's side. And in causation, what comes to my mind there is this interesting development we're seeing in the courts when it comes to the introduction of science into the litigation cases, the climate litigation, and what science are you relying on, what is sort of an accepted science, what is new science, and what is science-based attribution, and how large does your share of the emissions need to be if you are a corporate to make that link, as was pointed out before. So I think that's also an area we will see much development going forward. We are not there clearly yet. And on the question of supply chains, we have heard on the challenges of the supply chains earlier today as well. And I don't have any clear answer to that, and me neither. But I would say that, speaking from my experience from having sort of been in commercial disputes for quite some time, this is sort of it's in a situation where you have many different parties involved at different levels, to the extent that you as an actor in that system are able to control it, to be able to somehow streamline the dispute resolution provisions in that system. That would be a good first step. I realize that it's not always possible in all supply chains. You cannot reach all the way down, but it is surprising how many times, even where it would be possible, that is actually not done in certain systems involving several commercial actors. So that could be a minor but still important first step.
Thank you. And Tomoko, I know that it's very late in Nagoya, so maybe you can make it short.
Okay, I think I will also pick up the question about the absence of obligations covering supply chain. So I think that law is developing rapidly on this account. And I mentioned briefly about the codification of corporate due diligence covering the global supply chain, the French due diligence law, German LKSG, and the EU CSDD all provide corporate human rights and environmental due diligence obligations concerning their global supply chain. And in the climate change context, a case called Notre Affaire Atout versus Total, it was based on this French due diligence law, duty of care due diligence law. And maybe also relevant is the fact that some recent investment treaties, including the Morocco-Nigeria bilateral investment treaty, provide that when the investor's conduct results in certain significant damage in the host state, such conduct is subject to civil actions for liability in the investor's home state, or the rules concerning jurisdiction of the home state. So these development might, to a certain extent, address the concern over the absence of global supply chain, climate change obligations covering supply chain.
Thank you. I know that we are well over our time, so we would like to end the session now. This is my fault, and it's not the speaker's fault. But I'd like to ask you to join me in thanking the speakers for the wonderful presentations that they have given and the insightful insights that they have been able to share. Thank you. And I would like to give the floor to Angelo for some announcements.
Yes, thank you very much, Jay. Now we'll be proceeding to installing immediately the high-level round table that should begin according to our program within 1 minute. But before I do that, within the Commission's indulgence, may I just, since some of the speakers had already left because they had flights to catch and some might leave us before the end of the day, to place on record the gratitude of the Secretariat for all the speakers today and yesterday. The fact that so many so highly knowledgeable and busy people were willing to come here, most of them at their own expense, is not only a tribute to the convening power of the United Nations and this particular commission, but is also a service that they all agreed to devote to a common cause, and I think they deserve our appreciation. And the Commission report does not usually cite names, but I hope the Commission would be agreeable to the Secretariat annexing the program of the Colloquium to the report of the Commission so that the speakers would have a written tribute to their participation. And so, again, our heartfelt thanks to all of you for having joined us, and have a safe journey back. Thank you. That concludes the session.
Alors, si je peux vous inviter à reprendre vos sièges. J'ai le très grand honneur de présider ce dernier panel de ce colloque après presque 2 jours pleins d'échanges d'informations, d'échanges d'idées, de communication d'informations.
Exchange of information, to be able to chair this final session this afternoon, and also to have the pleasure of presenting to you this final panel with most distinguished representatives representing the diplomatic community here in Vienna.
We have this round table, and Excellencies, we have representation. We can hear first, I think, let me introduce the panel. Her Excellency, Mrs. Philowan Mangla Tanukul, and I apologize for my pronunciation, Ambassador of Thailand. We also have His Excellency, Mr. Armin Papikian from Armenia, and du Maroc, Excellence.
His Excellency, Mr. Azzedine Ferran, Ambassador of Morocco, a great pleasure, and of Paraguay. Once again, the pleasure of the company of His Excellency, Ambassador Faceti Fernandez of Paraguay. So once again, thank you to you all. Thank you all very much for honoring us with your participation here today.
I could open a round of comments, and I would start then with Ambassador Mangla Tanukul from Thailand, please. Thank you.
Thank you, Madam Chair. It's a privilege for me to be here and to see you again, because I have worked for UNCITRAL in my early years at the Ministry of Foreign Affairs, so many years there. So it's grateful that I get opportunities to see people in UNCITRAL, especially the Secretary as well, and the Secretariat. So thank you very much for having me today to share my thoughts on this very important and very timely issues for the world today. I wish, first of all, to express my appreciation to the Secretariat for organizing this important colloquium. And I also thank all the moderators and speakers and participants. I was not be able to attend, in the past 2 days, but I have been followed through my colleagues at the Thai representation, and I have known that there is a very fruitful engagement and contributions and discussion in the past 2 days. I'm very delighted to see us coming together to explore this confluence between international law and climate change in our collective efforts towards a carbon-free world. To say that because Thailand is among countries that most affected by the long-term risk of climate change. And we already involved in the sea level rise, and Bangkok is one of the 10 countries that might be sink, in the coming years. So, but we haven't thinking of moving the capital yet. We have called for a greater balance between mitigation and adaptation, including urging developed countries, at least to double their collective provisions of climate finance for adoption from 2019 levels by 2025. So on our part, we pledge to achieve carbon neutrality by 2050 and net zero emission by 2065 at the COP27 last year. I know that is very ambitious, but I think we set our goal very high in order to boost our domestic regulations and improvement of this very important topic. For climate action has been incorporated in our 20 years strategic national strategy framework for the year 2015 to 2050. I wish to emphasize that to help us and other countries achieve our emission targets, we need to strengthen international cooperation, especially on finance, technology, and capacity building. Against this backdrop, Thailand welcomed the initiative by UNCITRAL Commission to address the key questions of how UNCITRAL can contribute to the global efforts to combat climate change. In our view, it is both feasible and desirable for UNCITRAL to undertake the work on the climate change and trade law, given the important role that private sector can play in the decarbonization of the economy, and in light of UNCITRAL clear mandate and expertise on trade law, which make it well placed to take up this work in this area. Such work could help ensure the complementarity between efforts UNCITRAL and other frameworks such as the UNFCCC, the Kyoto Protocol, and the Paris Agreement. I think the cooperation between the public and private sector is crucial to fight against climate change. This has been emphasized in Paris at the summit of the new Global Financing Pact last month, with a new global financing architecture and more support for developing countries were discussed. Our colloquium has explored further various aspects of the private sector engagement in the fight against climate change. We have heard about various tools and mechanisms such as carbon credits, green bonds, Green Investment Initiative, and Climate Response Cooperation Conduct and Dispute Resolution. So I think it is very important that the permanent mission here in Vienna and in New York have a clear understanding of these issues and the nexus between the international trade law and climate change, so that we can mobilize the relevant agency and actors on the ground. For the discussion that we have in the past 2 days, I found Section 5, Corporate Social Responsibility, Due Diligence, and Disclosure of Climate Impact to be of particular interest. These are concepts that are already familiar with many countries and private sector itself. Thus, this can be readily adapted to serve environmental objectives. Indeed, Thailand has been at the forefront in promoting corporate social responsibility, and that's reflected in some of the previous work of the UNCITRAL. And we have sought to implement the responsible business conduct to encourage more climate responsible corporation conduct. I also found Section 3 on green investment certification and compliance interesting. For Thailand, our Board of Investment has put in place incentives to stimulate machinery transitions to the new machines that will help reduce the greenhouse gas emissions. There is also an ongoing discussion in Thailand on the possibility to provide tax incentives for the carbon capture and storage for businesses that conduct exploration and production of petroleum. Another session that I found that's very promising is the Section 2 and Section 4. Those two sessions highlight the usefulness of financial instruments for emission reduction and legal issues that could form the basis for UNCITRAL work in this area as well. So at this session, various issues has been already identified. Many of these issues are new and complex, and warrant further discussion with UNCITRAL. But given that for many countries, the developments on this area are still at a very early stage, it would be beneficial in principle to develop legal rules or guidelines to ensure the legal certainty and security for buyers and sellers, traders, platforms, financiers, and other relevant stakeholders. So it would also be useful to have a clear and detailed roadmap to help us navigate these various issues. In developing this roadmap, I think it is important to ensure that the widest possible participation from developing countries and encouraging that all sectors, both private and public, to be involved. This is crucial for the development of legal standards that are acceptable to and useful for all. But I think this is not new for UNCITRAL. UNCITRAL has already been a champion for reaching out to member states and stakeholders in various aspects. In designing the said roadmap, it would also be necessary for UNCITRAL to cooperate with other agencies, which organizations as well that are working on these issues. On our part, Thailand stands ready to contribute to these discussions, as always, with all interested parties, including with international organizations, associations, and NGOs, so that we can better align international trade and investment rules and policy with the climate objectives. Thank you.
Thank you very much, Ambassador. I think you've really given us quite a lot to think about, pulling together some of the ideas from the last day and a half. At this point, perhaps I will turn then. Donc je donnerai la parole.
I will now give the floor to the Ambassador of Morocco. Your Excellency, you have the floor.
Moderator, first of all, I would like to congratulate the United Nations Commission on International Trade Law for the organization of this important colloquium at a crucial time when we all need to take action, collective action with our respective roles and mandates to save our planet. Madam Anna, I would like also to extend my thanks and appreciation of the Secretary of UNCITRAL, Madame Anna Jobin-Brett, and her team for their tireless effort in conducting and preparing this important meeting. Distinguished colleague, I would like to start my remarks by firstly highlighting the contribution of Morocco to the global effort in combating, climate change. First, the Kingdom of Morocco is committed to support this global effort of the international community to face the climate change. In this regard, it is worth recalling that the Kingdom signed the United Nations Framework Convention on Climate Change in 1992 and ratified in 1995 and organized for the first time in Africa, I say in Africa, in 2001, the 7th conference of the parties, which made operational the Kyoto Protocol. Within this dynamic, Morocco organized in November 2006 in Marrakesh for the second time the conference of the party, which was marked by a series of commitments for the implementation of the Paris Agreement. At the regional level, Morocco is committed to make climate issues in Africa as a priority and calling for the climate justice in this continent, which is suffering from harmful consequences of climate change, even though it is the continent with the lowest GHG, greenhouse gas emission. In this context, I would like to recall that His Majesty, the King Mohammed VI, took the initiative to organize for the first time the first African Action Summit in the margin of the COP22 in November 2016, which was an opportunity for the African leaders to coordinate and harmonize their action in the first to fight against climate change, as well as to seek best solution to climate change faced by our continent. At this summit, African heads of the states committed at the initiative of Morocco to accelerate the implementation of initiatives aimed at strengthening Africa's resilience to climate threats, including the African Adaptation Initiative, the African Agriculture Adaptation AAA, as well as SSS, security, stability, and sustainability. Moreover, Morocco believes that strengthening cooperation to address climate change should be materialized through a consistent continuation of the implementation of the Paris Agreement, which provides in its Article 4 for the communication of the nationally determined contribution NDC every 5 years, starting in 2020. The Kingdom of Morocco began in 2020 the revision of its NDC, initially submitted to the Secretariat on 19 September 2016, following its accession to the Paris Agreement. The adjustment, just for your information, targets a 45.5 reduction in the greenhouse gas emission by 2030. So 18.3% of this target is unconditional, and the remaining 27.2 is conditional on international assistance. So in this respect, Morocco indices have been revised and reviewed, demonstrating the Kingdom of ambition to contribute fully and to the extent of its current and project socio-economic capacities to the response of climate emergency highlighted by the IPCC report, and in particular to the global objective of climate neutrality. To this end, a process of elaboration of low carbon development strategy to 2050 has been launched in early 2020 in order to reach an integrated, common, and shared vision establishing the main orientation of Morocco economy and society between 2020 and 2050. This process is part of a reflection that has been carried out by the Special Commission on Morocco Development Model and constitute a strategic catalyzer to make the recovery plan in response to COVID-19 pandemic equitable, sustainable, low carbon, and resilient. This ambition, I would like just to share with you that 7 objectives was set up. First, accelerate the strong development of renewable energies for decarbonized electricity with an indicative target of 80% by 2050. Second, increase the electrification of use of the industry, building of transport sectors, and evaluates the development potential of green hydrogen to decarbonize industry and road freight. To generalize energy efficiency and in order to use the natural resource in all sectors while developing standards and quality infrastructure of construction and equipment. Stimulate the circular economy, waste reduction and recovery, develops sustainable and resilient agriculture and forest ecosystem and carbon sinks, And finally, promote a new generation of low carbon and smart cities, including through systemic integration of digital transitional technology in all socio-economic sectors. Ladies and gentlemen, Morocco is actively participating in UNCITRAL working group, whether on dispute resolution or the reform of investors, state dispute, settlement or digital trade. We value the contribution to law reform in Morocco to make it more attractive to trade. And let me, before closing, I would like to share with you some remarks that could, of course, be like a food of thought for our discussion after this panel. We understand the importance for the private sector to have legal certainty and a clear legal regime when investing in climate change. In UNCITRAL, we highly appreciate and value the participation of NGO representing business and practitioners and which are taking part in the work of the working groups. And I think that it is obvious for the public sector to involve the private sector through public-private partnership projects. It is very important to underline this partnership between private and public sector, but we also need to harmonize and to have clear rules, to make sure the private investment contributes to the billions of dollars that are necessary to decarbonize the economy, especially in our countries. We need to develop the legal infrastructure for private sector involvement in the carbon and green bonds markets. We need to ensure that the rules are clear for compliance, because the main issue is the compliance and the follow-up. If we don't follow up, we are not able to comply, of course. And also we need clear mechanism to settle disputes arising from the market and non-market transaction and commitment. We believe that it is important for my country, as for other developing economies, to be closely associated and to participate in the discussion around the legal infrastructure to provide the private sector with the necessary legal certainty and legal incentives. We also realize that this new market and new market mechanism are multifaceted and complex, and therefore we believe that it is important to have a clear mapping. I say clear mapping of all the legal issues that arise. We recall with the interest the taxonomy approach the Secretariat adopted to map legal issues of the digital economy that led to a solid work program. We think that the same approach could be very useful and would encourage the Commission to take it for this new area of in international trade. Morocco is willing to contribute positively to the debate with other states, with other partners, interested international organization, representative of private sector and practitioner. But faced with a global challenge, we think that we need, within this global effort, we need global response. And we must also make our contribution to the design of the legal infrastructure. We believe that UNCITRAL as a body, as a relevant body of United Nations, is well placed to contribute within its mandate, and of course to contribute to this debate today, international debate on climate change. The universal membership of UNCITRAL offers the development countries an inclusive forum to develop legal rules and standards that will work for all and achieve a global goal. Thank you, Madam Moderator.
Thank you very much, Ambassador. Again, much to think about. If I could turn now then to I would turn now to Ambassador Papikian from Armenia for your perspective. Please, you have the floor. Thank you.
Thank you very much. Thank you very much, Madam Chairperson, Madam Moderator, and allow me to join previous speakers and colleagues and congratulate you upon your election as the chair of the UNCITRAL, and I wish you all the success in leading this extremely important commission. I also would like to extend our appreciation to the Secretariat for organizing this colloquium on climate change and the law of international trade. The selected topics of the discussions and the excellent thought-provoking presentations by panelists yesterday and today indeed helped us to have a comprehensive and in-depth understanding of the issues related to the carbon trading, clean or green investment, and the regulatory risks to which market participants, in particular the private sector, is exposed to, as well as climate disputes and their legal implications. Madam Chairperson, dear colleagues, Armenia strongly supports the climate action at all levels, within all possible frameworks, and seeks to actively engage and contribute to these efforts. Suffice to recall that in 1993, Armenia acceded to the UN Framework Convention on Climate Change. In 2003, to Kyoto Protocol. In 2016, Armenia signed. In 2017, ratified the Paris Agreement. And as a landlocked country, Armenia falls under the category of non-Annex I states, as defined by the UN Framework Convention on Climate Change, is particularly vulnerable to the efforts of climate change and is susceptible to negative impacts resulting from response measures. Since Armenia lacks its own hydrocarbon resources, achieving carbon neutrality is closely tied to the country's goal of energy independence and energy security. Therefore, we have accelerated our efforts aimed at transitioning to a greener economy, which is more sustainable and low carbon, and have taken concrete steps to actively integrate global climate agenda into our development policies. For example, for that purpose, we have embarked on a comprehensive review of our economic development model. In 2021, government of Armenia adopted the updated national determined contributions as part of its commitment under the Paris Agreement, setting the targets to be achieved by 2030, including a significant reduction of 40% its greenhouse gas emission from the 1990s level. These targets primarily focus on policies and measures in the energy sector, as well as efforts to mitigate the impacts of climate change on the country. The Armenian government, as part of its 2021-2026 action plan, prepared a decision on a long-term low-carbon development strategy of Armenia within the framework of the Paris Agreement on Climate Change, which is being finalized. Additionally, climate law, which will soon be submitted for public discussions, aim to strengthen Armenia's efforts to combat climate change and envisages the establishment of a comprehensive framework for addressing environmental challenges. The government has also implemented several initiatives to promote renewable energy and energy efficiency, as well as encourage the adoption of green procurement practices in public procurement. Furthermore, starting from 2023 this year, climate change considerations are integrated into the rating criteria for public investments. Madam Moderator, we attach great importance to cooperation under Article 6 of the Paris Agreement, seeking to actively promote and contribute to mitigation outcomes beyond our domestic efforts, and engaging in cooperative approach that facilitates the use of internationally transferred mitigation outcomes under Article 6.2 of the agreement. Additionally, Armenia aims to participate in projects mechanisms outlined in Article 6.4. By doing so, the country can generate additional mitigation outcomes that could support the fulfillment of NDC goals in other nations. We acknowledge the potential benefits of projects mechanisms envisaged under Article 6 of the Paris Agreement and recognize significance of non-market approaches as stipulated in Article 6.8. Now, coming to the discussion about carbon credit. I should state that the Armenian experts also identified uncertainties related to private sector engagement and the aspects of legal treatment of carbon credit. These are issues that could be addressed both at the domestic level but also at the international level. We have listened carefully to our distinguished panelists, and the need for having international legislative guidance came across clearly. And we concur with the opinions expressed by a number of panelists that there is a need for international legal standards setting bodies to explore the possibility of developing some international guidance in this respect, which could be of particular importance for those countries that have not yet established legal frameworks for the generation and the trading of carbon credits and other green bonds. Madam Moderator, we appreciate the work carried out by the Secretariat so far in implementation of decision by the Commission. In particular, the study on private law aspects of climate change, in our view, outlined the possibility of the Commission to contribute within its mandate, of course, to global efforts to combat climate change and mitigate its impact, especially on developing countries. Armenia always advocated for integration of climate dimension into the work of the UN as global intergovernmental organization with universal membership. At the same time, to succeed in achieving our goals of climate mitigation, adaptation and resilience, our efforts should be comprehensive. That is to say, every aspect and every issue that would contribute to advancing the global climate agenda should be explored. To succeed in our ambitious climate change mitigation goals, we need the whole of society approach, with the engagement of the private sector being indispensable. Only through close public-private partnership, through bringing the private sector on board, could we generate the necessary investment to implement the climate transition, the transition to new net zero greenhouse gas emission models of economy. We have also understood from the very interesting discussions that there is still a lot of uncertainty regarding the legal nature of some of the tools and mechanisms available, especially in respect of voluntary carbon markets that is necessary for the private sector, for banks, for businesses to trust and to invest. And this is where exactly we can see a role for UNCITRAL, to explore the possibility of developing a guidance for a legal framework for such climate action elements as carbon credits, voluntary carbon markets, green bonds and others that member states could then use to develop their climate-related national legislative frameworks, which is an important step towards operationalization and effective implementation of UNFCCC and the Paris Agreement. And the last point, if I may, Madam Chairperson, insolvency, dispute resolution are the issues also related to the climate transition that UNCITRAL, in our understanding, in our view, could look into. So I will stop here and thank you very much for your attention.
Thank you very much, Ambassador. I think I'm hearing some common themes. Not surprising, but a great deal of support. And now I have the pleasure of turning to Ambassador Fachetti Fernandez. I look forward to hearing your comments. You have the floor.
Thank you very much, Madam Chairperson. I would like to congratulate the Secretariat for organizing this high-level colloquium on this very relevant and important issue. And also I'm very glad to share this roundtable with such a distinguished colleagues here from Vienna. And my presentation is about why my country is supporting so much this tool, carbon credits, and especially the voluntary market. As I mentioned yesterday, we are, I will give you some figures from the 14 or 13.5 million of hectares that we have available in one region of the country. 100% of this land is on the hands of the private sector. So the private sector needs incentive to conserve the forest. And I mentioned also yesterday that when I was Minister of Environment, and we did very important reforms in order to promote conservation, but also we try to implement or to enforce law in order to stop the deforestation. So I would like to, can you reduce the sound? Okay, this is a presentation. I will give a short introduction, the trends regarding the evolution of the forest conservation or deforestation, the key policies implemented by the government, and the implementing measures at this time. So, as you can see, Paraguay is in the heart of South America. And in this, in the second image, you can see the country. The country has the shape of the country has two parts divided by a big river, the Paraguay River. The eastern region, you can see, is it holds the one of the very sensitive and one of the global hotspots in terms of biodiversity, which is the Atlantic forest. And on the western part of the country, which is known as the Chaco region, and we have a very unique bioma, a combination of biomas also, and it holds is the second largest forest region in Latin America, and one of the most important also in terms of biodiversity. Regarding the chart that you see below, and I just wanted to show you two important figures. The contribution to the GDP by agriculture, which is between 10-11%, and also the energy generation. We are exporting the energy that we export is responsible by a little bit more than 7% of the GDP, and is 100% clean energy. Another important fact that I have to mention is that we are a 7 million country with 7 million people, but we produce food for 75 million people. So that's why agriculture is so important. And I want to show with these figures that the main threat or challenge to conserve forest is agriculture. So in this region, as I mentioned, we have still 13.5 million of hectares, and 100% of this surface is the surface is in the hands of the private sectors, and since 2007, considering the whole country, most of the deforestation was concentrated in this part of the country. And as I mentioned also, the forest has been converted to agriculture, for agriculture use, as well as for cattle raising. Another figure is that from 2017 to 2018, 244,000 hectares was recorded, and 75% of this deforestation this land were legally cleared, so under laws and regulations. Regarding the eastern region, the forest cover was reduced from 55% from the 70s to about 16% in 2005. So it was a very high deforestation rate responsible for this situation in such a short time. But in 2006, the deforestation rate were reduced in 85%. It's because we implemented a moratorium to avoid the land use change. So this is the chart, the figure that I wanted to show you, and you can see clearly how we did, or why this reduction. But also parallel to this law, we also prepare another law which is very important. Is known the law for tradable rights, and is the law of valuation and remuneration for environmental services. And also we applied and we participated in a UN RED program and Forest Carbon Partnership Facility, which was sponsored or funded by the World Bank. So regarding the key policies, we are investing in the forestry governance sector to improve the governance and management capacity of the sector, and the aim of this strategy is to reverse the current trends by improving the governance and effectiveness in the forestry sector, strengthen the weak business environment, which is very much related to the forestry activities, reverse the poor access to credit and markets, and the absence of green certification in the forestry sector. Another very important initiative that we took and we are following is the CBR Plus project. This is a community-based RED Plus project, and it helped a lot to show communities how to participate in how to participate in the project preparation and also project implementation. What we are doing specifically regarding carbon credit is the amendment of the law that I mentioned before, the tradable rights, in order to address the weak business for conservation of forest and to regulate the voluntary carbon market. And we are seeking to establish the legal rights for GHG emissions, to identify holders and to create guidelines and regulation for the trading markets and addressing the absence of national regulations. So the final remarks is that the necessity, I would like to clearly state that we need this legal framework that regulate the voluntary carbon market, because in order to support those companies that are offering their carbon credits, we need this legal framework. And finally, we need also these guidelines for private companies to achieve high integrity in carbon credits, but ensuring transparency, accountability, and continuous improvement and the overall quality of carbon credits. Thank you very much. 10 minutes.
Thank you very much, Ambassador. We have time now for some discussion. In terms of the common threads, I think through the comments that we have just heard, legal certainty is, I think, a top item on the list. I think what I also heard from the comments is that it's not enough to focus on one area. There are many issues that require some form of legal response or legal framework, and to really facilitate the goals in emission reduction, mitigation, adaptation. I'm learning the vocabulary of the subject matter. We need to take an integrated approach and address maybe not all of the issues all at once, but a roadmap was mentioned a couple of times, and that's the taxonomy suggestion that we heard mentioned. in order to take a structured approach to effectively finding solutions to the problems that have been raised. But perhaps at this point, what I might do is open the floor and see if we have comments from anyone online or from anyone on the floor. The Islamic Republic of Iran, please. You have the floor.
Thank you, Madam Chair. I wish to thank the Secretariat heartfully for the putting together this very informative and rich discussion in panels. It was very good. We learned a lot. We have a better picture of the whole process at the moment. There were very good ideas about how to further develop, and we will take that back home and we work on that to see where we would stand. I took the floor just to raise one issue here. I was hoping to be hearing more on adverse effects of unilateral coercive measures on the cause of the climate change in terms of international trade law. When a company situated in a jurisdiction where it cannot buy the necessary equipment or the needed technology to address the issue of gas emissions it has, it should be differently in terms of the responsibility and expectations globally. So if that is not taken into account, whatever we develop here, we discuss here, would be if it develops something, would be an unjustifiable extra burden for the company. It cannot cover more where it cannot have access to what it needs to have, so it can fulfill those responsibilities. Stop here. Thank you.
Thank you very much for the comment. Madam Secretary.
Thank you very much. I hope you will give me the credit that I have been very quiet for these 2 days. I have listened and learned so much. And I also wanted to offer a glossary that we have put together to start navigating the terminology of this new area, which is developing with lots of acronyms. And our colleagues from the UNFCCC have shown us that there is a world of acronyms in the climate part of the UN. We thought that the UN was a creator of alphabet and of alphabet soup and of acronyms, but it has also sub-products in some specific areas. And of course, we are well aware that we also create a lot of jargon on our own. So it was an exercise also to put what we do and how we work and what we represent as a legal body of the United Nations General Assembly into this broader context, and see what we can do with our modest and very, very focused and limited means. So I just wanted to say that when we started working on these issues about 2 years ago, looking at the instigation of the Net Zero Lawyers Alliance and the United Kingdom, we started looking at it with our main instruments, our areas of work, our traditional areas of work in the back of our mind. We looked at our insolvency framework, at, of course, the rules on contracts, the work we do on secure transactions, and Also, gradually, the new areas of work that we are working on currently in terms of the digitization of trade, of these new commodities, for example, data as it is being traded, or the artificial intelligence and these new tools, for example, also the blockchain that we will be discussing later next week. Also the public procurement. We heard a number of references to the public procurement rules or the public-private partnerships. So I was really, we really looked at it from that point of view, which was fairly atomized, but then seeing that there was a common thread. And this common thread, we can find it either by focusing on one particular mechanism of the Paris Agreement, or we can look at it from the entirety of international trade law and looking at how various areas of international trade law can make their contribution. So this is what we think at this juncture we really would like to carry forward with the Commission and with the Commission's blessing to transform this call we got for looking at what we do in UNCITRAL in the broader context, in part of the UN. What can you do? But also looking at it in terms of taking stock of our existing text and seeing where we can develop and contribute, and also being creative all together. So I really wanted to thank all those who participated in this colloquium, because for us it has been extremely enriching. Many of my colleagues have been listening in. I know that we had also numerous participants online for this colloquium, and it has really marked, and I'm sure that in the years to come we will continue to benefit from the discussions that have taken place during these 2 days. So thank you very much to my colleagues who have designed and put together the program, but also implemented it in the course of these 2 days. Thank you also to all the speakers that have taken part have contributed with their expertise and knowledge. And thank you to the excellencies who are joining us for this concluding roundtable, for the encouragements of our member states and of the membership of UNCITRAL and of the United Nations. That was the point I wanted to make before we close this event. Thank you very much.
Thank you, Madam Secretary. I have the Russian Federation. Please, you have the floor. Благодарю вас.
Thank you very much, Madam Chairperson. We have a few comments we would like to make. I'd like to begin by thanking the Secretariat of UNCITRAL and also the experts for the tremendous amount of work that has been done. It's tremendously important for building capacity and involving the private sector in implementing common approaches to implementing the Paris Agreement. Our position is that the Paris Agreement at the present time serves as a basis for international cooperation in combating climate change. The Paris Agreement platform has a unique mandate to determine the rules of international cooperation in implementing cooperation projects that aim to reduce greenhouse gas emissions. In accordance with the Paris Agreement, the international trade in carbon units should be only based on ITMO. ITMO is the instrument established by the Paris Agreement that is to be used by states parties to exchange emissions credits. So between states and integration bodies. We believe that the main issue to be dealt with by UNCITRAL when it comes to trading carbon credits should be formulated as follows. How UNCITRAL's work can help with work carried out at the Paris Agreement platform to build capacity within the private sector in implementing ITMO projects. I'd like to recall that the efforts at the Paris Agreement platform to establish rules of cooperation has not yet been completed. It is very important not to duplicate the work carried out by the Paris Agreement at the UNCITRAL forum. We must not duplicate the work of the UNFCCC either. We must carry out work in the private law area. So the issue arises as to whether UNCITRAL should carry out any independent work at all, especially at a time when the Paris Agreement has not yet completed its work. There is a real risk of duplicating efforts and coming to different outcomes at the Paris Agreement platform and at UNCITRAL. The outcomes of the work at UNCITRAL at this stage, we would see these as being determining a list of challenges at the private law level in terms of implementing joint approaches. Formulating that list is important for the forthcoming discussions at the Paris Agreement platform and should be taken on board by states when they develop approaches. Also, formulating this list of challenges should be a precondition for consideration by states of various issues in the purview of the working groups of UNCITRAL. The platform of the Paris Agreement has a capacity building element. Possibly UNCITRAL, together with the UNFCCC, could look at the possibility of carrying out research work to investigate private law aspects of implementing approaches under the Paris Agreement on capacity building. By way of conclusion, we'd like once again to thank the Secretariat and the experts for the work done. It does indeed play a very important role in formulating an international system for climate cooperation. Thank you.
Thank you to the distinguished delegate from the Russian Federation for expressing those views. I think the Commission will certainly have a full discussion of the material that we benefited from over the last 2 days, and we'll hear from many more delegations when we have the discussion in relation to UNCITRAL's work program next week. Brazil, you have the floor.
Thank you, Madam Chair, for giving me the word. I'd first like to thank the Secretariat and all the participants in the Colloquium for this outstanding event. We learned much here and are going to take very interesting elements to study at home. Thank you very much. I have but a few remarks to make. Brazil considers it important to point out that any discussion at UNCITRAL on climate change must necessarily consider the public international law applicable to the topic, the UNFCCC, its Kyoto Protocol, and its Paris Agreement. In particular, we believe the Commission should always bear in mind the principle of common but differentiated responsibilities expressed in these three legal instruments. It is our belief that the future notes and studies by the Secretariat on climate change should be prepared in a transparent, inclusive, and representative manner. In particular, with regards to the sources used and the external experts consulted, we believe the legal practice of developing countries from different regions needs to be better explored. I recall that it is explicitly stated in Resolution 2205 of the 17th of December 1966 by the United Nations General Assembly, which created UNCITRAL. The Commission shall bear in mind the interests of all peoples, in particularly those of developing countries, in the extensive development of international trade. We entreat the Commission to also keep in mind that one of the 4 criteria used to deliberate on the referral of new topics to the working groups is the risk of duplicating efforts in relation to other forums for legal issues. We consider it would be opportune for future notes from the Secretariat to systematically identify the forums active in each of the topics suggested as potentially relevant, making reference to the reports, negotiation processes, and deliberations that took place in those forums. Finally, Brazil believes that for the time being, it's premature to give a definitive approach to the issue of possible future work by UNCITRAL on climate change and private law. Brazil holds that the Commission should instruct the Secretariat to continue its research on the subject, taking into account the concerns expressed here. Thank you very much.
Thank you very much to the distinguished delegate of Brazil for those words. And I hope that you will be able to repeat the message next week as well when we get to the discussion, but certainly we will bear in mind the comments that we have received. Again, there was so much in what we heard over the last few days. I think the suggestion that the Commission not be too hasty in firmly fixing a work program may be something that we might want to think about for next week. At the same time, part of the message that we heard from all the experts this week was the importance and the urgency of action with respect to this area, so we don't want to prolong decisions any longer than necessary. So again, it's a question of striking a balance. We have a number of areas that have been identified, and I would join with those who have already expressed their thanks to the Secretariat. I think particularly Mr. Soyafaria, who carefully and thoughtfully and with great reflection, I think, structured the program and ensured the participation of speakers who are so well placed to help educate, I think, the members of the Commission in an area which is a different perspective for many of us. And I think one thing that we need to emphasize is the need for cooperation and collaboration. We heard already identification of different areas where UNCITRAL has the expertise. We know that obviously within the UN system, all the agencies and bodies that are already engaged in climate change. We know that UNIDROIT, we had mention of the three sister organizations, UNIDROIT, which already has some of this on its work program. We heard issues of private international law, classic private international law mentioned, which engages the Hague Conference on Private International Law. And it's going to be important for this Commission to, as it has done historically, continue to collaborate with all of those who bring expertise and knowledge to this area. At this point in time, I know that the Secretariat is going to have a challenge in terms of bringing forward to the Commission next week some kind of summary. I think it's a Herculean task to encapsulate everything that we've heard these last 2 days into a report for the Commission. At the same time, I'm confident that they are up to the challenge because I've seen you do it before. Honduras? My apologies. Honduras?
Rápido. No, al contrario, disculpe.
No, apologies for taking the floor at the very last moment, just the last few minutes. But first of all, my acknowledgement, as Brazil and the Russian Federation did previously, to the Secretariat for the excellent manner in which the meetings, the panels were held, very well structured, useful discussions, each panel on its subject matter. It strikes me that each member state here should carry out consultations back home or audits to find out whether our national governments are duly complying with all of the instruments that we have committed to. So ensuring compliance with these various conventions and treaties, all of which is necessary and which should be assessed through some form of audit carried out by a monitoring or oversight body in order to see where deficiencies lie, what is being upheld, what is not being upheld, what countries can do, in order to build further upon these experiences shared at these fora. Thank you.
Thank you very much to the distinguished delegate from Honduras. Those are wise words. Are there any further comments from the floor or online? No? Ambassador, please, you have the floor.
Thank you, Madam Chair. And I think it's very common that when UNCITRAL going to start on some work, and then there will be questioned whether it's duplications or not, to other works of other agencies. And for me, I have heard that delegations' comments that whether there is already existing climate change and environmental conventions on that. I think taking into account the very seriousness and the urgencies of this problem. I just come back from Geneva, and I think it's global warming is there. I mean, we are not prepared for it, and I think it will come very fast. So for me, I think it's all the efforts that we need to do from our various agencies in various aspects of international law should be something that we put focus on and put our energy on. And of course, for me to see, because UNCITRAL has already covered a lot of in private and business, and I think this can be a horizontal issue. So this would be applying to various areas of law, and that could be implemented in procurement, micro and finance. I don't know what to call the name anymore. International trade, and so insolvency, as mentioned by the Madam Secretary. And I think this is across sectors issue. So I think I'm sure that UNCITRAL, with its competency, we can be able to come up with something that's very useful for member states. As I already mentioned, that Thailand has implemented certain measures like incentive in various areas, tax incentive for business, and even corporate responsibility. This sort of thing, I think that is a business conduct that we can enhance by giving, advice, that there could be other measures that would be facilitating apart from market access that we've been deal in international or even the policy or hard law, I would say. But I think it's something. I'm very optimistic that we can come up with something. And also important is that to signal to the world that this is the problem that we have all responsible to tackle. Thank you.
Thank you very much, Ambassador. Please, go ahead, Ambassador.
Thank you, moderators. Well, I would like just to tell some words. I do agree with Anna, about her comments, that UNCITRAL Commission will be called in the upcoming years, of course, to continue, but to codify the trade law, as the international law is a progressive law, and I think that we will be called. And also, I would like to highlight this integrated approach and collaborative approach. It's very important because, we need this trade law perspective. Climate change is tackled from scientific or some angles, but we need this trade, because in the upcoming years we will be faced to some dispute. And then we need some rules to be elaborated by the Commission that could help states in the future, and also to contribute, because it will be specifics, and we need some specific answer from the Commission. So I think that the title of this colloquium, of this high-level member, possible work, I can say imperative work by UNCITRAL at the climate change from perspective private law. So I encourage you, and I think that the Commission has the potential to do that, and to have this interactive, to continue to have this interactive dialogue and discussion with member states, in order to see how we can contribute also as member states to the codification of the international private law. Thank you.
Thank you very much. So with that, perhaps, unless there are other comments, then I will, first of all, ask you all to express your appreciation to our distinguished panel for their comments, which I think wrapped up things and also gave us more food for thought. And our appreciation for the Secretariat for having really outdone themselves with this event. And just before we do express our appreciation, I would note that tomorrow we will return to the agenda for the rest of the session, and it will be we'll really have to switch tracks. It's been an immersion that has been serious, and so we'll take up our work with respect to the draft guidance text on early dismissal and preliminary determination. That text, which would be included in the UNCITRAL notes on organizing arbitral proceedings, and tomorrow that part of the session will be presided by our Vice Chair, Andres Llana from Chile, as he is the chair of the working group that produced that text. So at this point then, I will declare our session closed and ask you to express your appreciation. I'm sorry, Israel is asking for the Israel? Before we express our appreciation. After? Yes. My apologies. Thank you all.